All right, so today we're jumping into a story that, on the surface, sounds pretty simple. You've got a classic ballpark brawl, an angry fan, a frustrated umpire, one punch. But, and this is the crazy part, this isn't just about a fight. It's about what happens when that brawl moves off the field and into the super complicated world of insurance law. So let's dive in.
So here's the big question right up front. Seems simple, doesn't it? If you deliberately punch someone, you're on the hook for it yourself. I mean, insurance is for accidents, right? Not for stuff you do on purpose. But what if the law sees it differently? That's the whole mystery we're going to unpack here.
Yep, you heard that right. In one real case, a court in Louisiana looked at a punch that was thrown on purpose and actually forced a homeowner's insurance policy to cover it. It all boiled down to some tricky fine print, a he-said situation, and a totally wild legal interpretation of just one single word.
Okay, so to really get how we ended up in this legal mess, we have to rewind. We've got to go back to the incident itself. And it all starts where, let's be honest, a lot of these stories do, at a small-town sports game where things got a little heated. So picture this. It's May 20th, 1987 in Ouachita Parish, Louisiana. We've got an adult softball game going on. It's a pretty typical weeknight game. You know the vibe. But then, one controversial call is about to change everything. And here's how fast it all went downhill. It kicks off with a call from the umpire, Jimmy Baugh, against the team sponsored by a guy named Maurice Redmond. Now, Redmond is not happy. He gets so enraged that he just spends the rest of the game screaming at Baugh from the sidelines. But it doesn't even stop there. After the game, Redmond actually follows Baugh off the field, keeps harassing him, and then, bam, he lands a punch right in his face. So when they get to court, the umpire, Jimmy Baugh, his story is really clear. He basically says, look, I was just trying to walk away, and this guy followed me. Baugh testified that the punch came out of nowhere, completely by surprise, and that he hadn't made any threatening moves at all. But then you have Redmond's side of the story, which is totally different. He claims that while they were arguing, Baugh suddenly turned towards him with his umpire mask in his hand. And Redmond says he genuinely thought Baugh was about to hit him, so he threw a punch in self-defense. So you've got two people, one punch, and two completely opposite stories. So with these two totally conflicting stories, the fight moves from the ballpark right into a Louisiana courtroom. And this is where a seemingly simple punch gets sliced and diced into some really complex legal questions. So, first things first, the court has to figure out, was this a battery? Now, the legal definition here is really interesting. It doesn't mean you have to be trying to seriously hurt someone. Nope. All it requires is that you intended to make contact with them and you didn't have their permission. That's it. Well, the court didn't have much trouble with this one. They sided with the umpire. They looked at how angry Redmond was, how he followed Baugh after the game, and they were like, yeah, he fully intended to hit him. That whole self-defense claim, it just didn't fly. So, legally speaking, it was a battery. But we are far from the end of this story. This is where Redmond's lawyers get clever. They argue that, okay, even if he threw the punch, Baugh wasn't some innocent bystander. They claim Baugh's own words and actions helped stir the pot, so he should have to share some of the blame. And in the legal world, that's a concept called comparative fault. So how do they decide that? Well, the court doesn't just go with its gut. They use a very specific legal test. It's actually a pretty cool look at how judges break these things down. They have to weigh all these factors to figure out if the umpire's own behavior played a role in him getting hurt. And after going through that whole checklist, the court's decision was, pretty clear-cut. They found that Baugh was just trying to get away, while Redmond was the one pushing for a fight. The final verdict? Redmond was 100% at fault. The umpire? 0% of the blame. So, case closed, right? Not even close. Okay, this is where the story gets really interesting. So Redmond's now on the hook for Baugh's injuries. And he does what a lot of us would probably do. He files a claim with his homeowner's insurance. So he goes to his insurer, Aetna, and asks them to cover the damages. And Aetna basically takes one look at the case file, sees deliberate punch, and just, nope, they deny the claim. And honestly, their reasoning seems pretty solid. They pointed to this one little clause that's in pretty much every liability policy out there. It's called the intentional injury exclusion. And it says, flat out, that the policy will not cover injuries that are expected or intended by the insured person. Aetna's logic was super simple. Redmond intended to punch Baugh, so the injury was intended. End of story, no coverage. But then, Redmond's lawyer comes back with this really clever kind of mind-bending argument.
He separates the act from the result. He says, okay, sure, maybe Redmond intended the act, the punch itself, but he never intended the severe result, knocking the guy's teeth out and causing thousands of dollars in dental damage. Redmond even testified that he didn't think he'd hit him nearly that hard.
And just like that, this whole case, worth thousands of dollars, suddenly hinges on how you interpret one single word in an insurance policy. Intended. Does intended refer to the act of punching, or does it refer to the specific, severe result of that punch? Now, the first court sided with the insurance company, but Redmond wasn't done. He appealed.
So the case moves up to the Court of Appeal of Louisiana. And their decision, how they decide to read that one little word, is going to set a wild precedent and give us the final crazy twist in this story.
And here it is, the heart of the court's decision. They made this super important distinction. They said there's a difference between intending a minor injury and intending a severe one. So if you meant to cause just a little bit of harm, say a shove, but you accidentally cause a way more severe injury, that insurance exclusion doesn't apply to the unexpectedly severe.
So this is what it all boiled down to. The appeals court actually believed Redmond when he said he only meant to throw a sharp, quick punch and that it was more of a provocative gesture than an attempt to cause serious harm. And because the actual dental damage was so much worse than the minor injury he claimed he intended, that exclusion clause didn't count. Aetna was on the hook. They had to pay.
And what did they have to pay? A cool $24,800. That covered Jimmy Baugh's pain and suffering, all his medical bills, his lost wages, the whole shebang. And this was all being paid by an insurance policy for an act that another court had already decided was an intentional crime.
Oh, and to add a little insult to injury for the insurance company, the court also ordered Aetna to pay Redmond $3,000 to cover his lawyer's fees for having to sue them. Ouch.
So this whole case of the softball punch leaves us with this really fascinating question, one that goes way beyond a sports field. It really makes you think about intent, about responsibility, and about how the law even begins to draw a line in that fuzzy gray area between what we mean to do and the damage we end up causing.